Gentlemen, time is very short this morning, and perhaps it's because I was so happy to speak to you that I talked a bit too much. But the first day is always a bit tight. So let me introduce to you the first moment of our winter courses, the first important moment, which is the opening lecture, who will be given by Professor Chimni. Professor Chimni is Distinguished Professor of International Law, UP Jindal Global University, Sonipat, India. Previously was, for over 3 decades, Professor of International Law at the School of International Studies at the Jawaharlal Nehru University. He has been a visiting professor at Brown and Tokyo universities, the Graduate Institute Geneva, and the American University of Cairo. And he has been visiting fellow at Harvard, Minnesota, and York, Canada universities, and the Institute of Advanced Studies at Nantes, in Nantes. He's an associate member of the Institut de Droit International and member of the Academic Council Institute of Global Law and Policy at Harvard Law School. He is former vice president of the Asian Society of International Law and at present is a member of its advisory council. In 2022, he was honored by the American Society of International Law with its honorary membership. The University of London has instituted a scholarship in his name for the MA in Refugee Protection and Forced Migration Studies by Distance Learning. He has also received an honorary doctorate from the University of Gothenburg, Sweden. He has delivered several prestigious lectures, most recently the 2023 Lauterpacht Memorial Lecture at Cambridge University in the UK. He is the author of International and World Order, a critic of contemporary approaches. He is closely, as you all know, associated with the third world approach to international law movement. So we are very happy to have Professor Chimni with us. We've read a lot, Professor Chimni, so hearing him will be a joy. Thank you, Professor, for being here, and please come to the podium.
Good afternoon to all of you. Thank you, Secretary General, for those kind words. In fact, I would like to begin by thanking the Hague Academy of International Law for giving me this privilege and honor of delivering the inaugural address to its 7th winter course. As you know, the subject I've chosen to discuss is international law and global justice. I'm acutely aware that I have decided to address a subject which is vast and complex. If I have yet chosen to speak on the subject of international law and global justice, it is because, in my view, the international community cannot effectively address the ongoing, multiple interlocking crises manifesting in wars, genocide, poverty, inequality, disease, refugees, climate change, and the retreat of democratic practices and norms without raising the question of the unjust nature of the global order. In other words, these crises are in significant ways the outcome of an unjust global order sustained by modern international law. If the latter reality is not readily recognized, that is, the reality that international law sustains an unjust global order, is not readily recognized in the discipline of international law, it is principally because what I call mainstream international law scholarship relies on a positivist epistemology that does not acknowledge the central role of power and capital in shaping modern international law. Equally significantly, mainstream scholarship proceeds on the assumption of mainstream social science literature that the nation state and not the global system is the relevant unit for justice analysis. And I'll come to this in detail, that to speak of justice is always to speak about it in the context of a nation state and not the global order. The absence of, in other words, the absence of interdisciplinarity and what is termed methodological nationalism prevents serious engagement of mainstream scholarship with, among other things, the causes and consequences of the different ongoing crises, the complicity of international law in producing them, and the need to pursue the goal of a just global legal order. In short, despite the crucial role of power and capital in framing, shaping, and observing international law and the resultant spaces of global injustice, mainstream scholarship is, given its epistemic insularity, averse to exploring the role of international law in actively pursuing the cause of global justice, other than perhaps to the extent codified in positive international human rights law. In the rest of my talk, I'll sustain the case for a firm relationship between international law and the goal of global justice in 4 steps. However, at first I wish to clarify that what I'm not going to do is to take any particular crisis or offer an overview of the multiple crises to demonstrate the unjust nature of the global legal order. My lecture has a theoretical orientation with a focus on addressing the epistemic hurdles in linking international law with the goal of global justice. However, yet, in order to set the stage, I will mention at first 2 crises, that of poverty and inequality, and on the one hand, and climate change on the other. I will thereafter, secondly, deal in detail with the different epistemic objections advanced in the literature of international law and social science against establishing a strong relationship between international law and the pursuit of the goal of global justice. I entirely appreciate that the discussion that I'm going to present raises abstract conceptual issues at a time when gross injustice of situations and regimes stares us in the face. But there is, in my view, no alternative but to step back and undertake the epistemic exercise of looking at why the linkage has not been yet established to work towards establishing a just global order. The contestation of questionable epistemological and ontological assumptions that inform mainstream scholarship's approach to the global justice must urgently complement critical commentary on unacceptable situations and regimes, as these prevent advancing the appropriate sociological framework for devising an appropriate response to them. So while we have critical commentary, critical approaches to different situations and episodes, what we yet do not have is critical engagement with the concept and idea of global justice and why it is not seen as a value that is worth pursuing at the global level. For otherwise, what may happen is that you and I may keep speaking of global justice, but mainstream scholarship and powerful states do not see the idea of global justice as relevant at all. And that's what I'll try to explain why they don't see it as relevant. Thereafter, thirdly, I'll discuss the analytical and heuristic value of posing a positive linkage between international law and global justice. What are the advantages of doing so? Finally, I will turn to the question of agency and speak of the social forces and actors that can promote the realization of justice in the global legal order. I will suggest that a coalition of global South nations, key international organizations and tribunals, and global social movements must play a critical role in the struggle for realizing the goal of global justice. I will now, as I said, to set the stage, mention very briefly 2 crises And I have chosen crises which are less controversial, as if it were, because I don't want to distract from my larger discussion. The first crisis is that of poverty and growing inequality. It is true that in recent decades, millions of people have been lifted out of absolute poverty in countries like China and India. Yet the current World Bank count of global poor is a significant number. Based on the revised poverty line of US $2.15 a day, it is estimated that 700 million people live in extreme poverty, concentrated in parts of sub-Saharan Africa, fragile and conflict-affected areas, and rural areas. But the figure does not represent the whole truth. There is continuing debate on ways of counting the poor, the global poor, a debate that's been going on for decades. Two leading critics of the World Bank criteria have pointed out that its approach to estimating global income poverty is neither meaningful nor reliable. In their view, and I quote, "The bank uses an arbitrary international poverty line that is not adequately anchored in any specification of the real requirements of human beings." World Bank figures show, and I stay with the World Bank, and I quote, "In 2022, 1.8 billion people subsisted on less than $3.65 per day. And note this figure, while 3.6 billion people lived on less than $6.85 a day. It is likely that climate change will substantially add to the numbers of global poor. The reason why these more realistic poverty lines are not used in mainstream literature is not only because the numbers of poor would increase in the developing world, but I would suggest it would reveal the extent of relative poverty even in the industrialized world. But going beyond the realm of poverty and deprivation, the unjust nature of the global order is also reflected in growing inequality within nations. It is always good to remember that the 26 richest people in the world hold as much wealth as half the global population. What kind of a global order is that? While there are growing inequalities in the global South nations, the rich nations are no exception. Thomas Piketty, in his well-known book, Capital in the 21st Century, and Nobel laureate Joseph Stiglitz, in his book, The Great Divide, document this problem. Overall, the World Inequality Report 2022 notes, since 1980, income inequality has increased rapidly in many regions and nations, including North America, China, India, and Russia, and more moderately in Europe. In short, a global class divide firmly coexists with the global North and global South divide. There are two kinds of divides today, a global class divide on one hand, and a spatial global North, global South divide, which is likely to have been more exacerbated in the wake of the COVID-19 pandemic and the war in Ukraine. In these regards, even if the role of problematic domestic policies is flagged, it cannot be anyone's case that international economic, law, and organizations have not actively contributed to growing poverty and inequalities, or so is that my case. Let me flag the other crises, that of climate change. The consequences of climate change, substantially as we all know, fall on those actors and peoples that have least contributed to global warming, these being nations and peoples of the global South. What is equally troubling is that there is only very hesitant effort by global North nations at regulating climate emitters, despite all the talk, who continue to cause climate harm. As the UN Secretary General noted in his report, Our Common Agenda, and I quote, "The countries that are members of the G20 provided over $3.3 trillion in direct support for coal, oil, gas, and fossil fuel power between 2015 and 2019. In 2019, 60% of the fossil fuel, please note this, 60% of the fossil fuel subsidies went to producers and utilities despite government's climate commitments. This is the UN Secretary General. The result is that fossil fuel subsidies distort prices and risk increasing investment in emission-intensive assets that place the goals of Paris Agreement out of reach. Indeed, Nobel laureate William Nordhaus has pointed out that, and I quote him, and this is very interesting, and he writes that even with all of the international agreements of the last 3 decades, the UN Framework Convention on Climate Change, the Kyoto Protocol, the Copenhagen Accord, and the Paris Climate Accord of 2015, along with, when he was writing, 25 conferences of parties, over the same period, he concludes, the rate of decarbonization has remained unchanged. So all these bundles of agreements, very little impact on in terms of regulating the actual emitters. It is, of course, satisfying that the Paris Agreement mentions the goal of climate justice in a preambular paragraph. But it's very interesting, and it's very clear from the words that precede it, that the goal of climate justice is important. And this is what the preamble says, only for some. Only for some, that's what the preamble says, that it is not a common goal. For it would call for a climate regime that responds to the historic inequalities in per capita emissions of global North and global South nations, the devastating effect of global warming on low-income nations, the grave problem of climate displacement, the imperative of transferring financial resources and technology to poor nations, and the importance of avoiding the phenomena of what is called green grabbing and carbon colonialism. In the face of this, I understand why the Paris Convention doesn't want to speak of climate justice. The Paris Agreement or COP meetings do not adequately address these realities. Put differently, it is not acknowledged that the forces of capital, that is global capitalism and empire, are primarily responsible for the climate crisis. Without such recognition, there is little possibility of pursuing the goal of climate justice. The existing dismal situation is captured by the Italian scholar Armiaro with the phrase Vestocene, he calls it, underscoring that global warming creates wasted people and wasted places, and yet very little action by those on behalf of those who can make a difference. Now, even a cursory discussion of the two global crises, poverty and inequality and climate change, shows that unless the global legal order is actively linked to the goal of global justice, these crises are unlikely to be effectively addressed. Justice must be placed up front. In other words, the question of redefining the telos of international law to include the pursuit of global justice is not merely an abstract proposition, and I want to underscore that, but has grave practical implications, including saving life on planet Earth. So that the epistemic questions I'm going to raise are not simply those which involve simply an intellectual exercise, empty intellectual exercise, but are very critical to real-world pragmatic action. Yet, despite this, many epistemic questions are raised against creating a firm relationship between international law and the idea of global justice. The subject deserves substantive discussion, and it is to that I now turn. The epistemic impediments are at least sixfold. These are as follows. The idea that in an interstate system, the value of order must be privileged over justice. The claim that the notion of global justice lacks epistemic validity. Third, that the meaning of justice is a very contested terrain and involves complicated questions. The view that the specification of the operative principles of global justice is a difficult task. the concern that international lawyers are not competent to undertake interdisciplinary analysis of international legal regimes. And finally, the assertion that positive international human rights law already addresses the justice gap in international law as it attends to the concerns and interests of the marginalized and oppressed sections of the global population. I will speak briefly to each of these objections. I'll take each one of these and try and respond to them. The first objection is, and this is implicit in mainstream scholarship, that the goal of global justice is a misplaced sentiment in a sovereign state system. The political scientist Terry Nader explained this view by emphasizing the need to distinguish between the ideas of what he calls purposive association on one hand and practical association on the other. Purposive association, according to him, and I quote, consists of relations among those who get together to further particular ends and who, if they adopt rules, adopt them as instrument of that pursuit, in this case, global justice. On the other hand, practical association is a relationship among those who are often at cross purposes but agree on rules on the basis of which each can pursue them. So these are two different paradigms. In his view, in Nader's views, it would be a mistake to regard the global legal order as being governed by the idea of purposive association, that is, by the idea of pursuing shared purposes. In other words, the goal of global justice, according to this view, is best served if the basic rules of interaction that are agreed upon by sovereign states are observed. But to the critics of this understanding, this is essentially an argument for the maintenance of status quo. The emphasis on practical association tends to legitimize all kinds of unfairness in international society, neglecting the fact that the fate of justice within nation states is increasingly determined by decisions taken in international settings. The question of justice of a particular regime, whether investment or trade or environment, has therefore to be necessarily raised because the decisions regard to them are taken at the global level. Moreover, confining the role of international law to the maintenance of order in international society can, in the final analysis, lead to creating conditions in which the rules of practical association can themselves come to be undermined. In other words, the binary between practical and purposive association is flawed and unpersuasive, that we can no longer not talk about shared purposes in the face of, and as I said, planetary level crisis. A second objection to establishing a firm link between international law and the goal of global justice is regarding the validity of the idea of speaking about justice at the global level. And there's a contentious debate here. The skeptical view, those who question the idea of global justice, is espoused or derived from the work of very well-known thinkers like John Rawls, David Miller, and Thomas Nagel. In this view, the idea of global justice is, among other things, not meaningful in the absence of a global demos, that is a global community, a thick community, and a global state. In their absence, there's no point talking about justice. In the event, according to them, the discussion should be confined to issues like offering humanitarian and development assistance to weak states in time of crisis. That is, you talk about justice, but in a very peripheral sense. The negative, the second view, which diverts from the Rawlsian, etc. view, has been advanced by scholars like Charles Beats, the socialist feminist Nancy Fraser, Thomas Pogge at the Yale Law School, and of course, finally, Amartya Sen. Their contention is that a national conception of justice is no longer justified, if it ever was, because, as I said earlier, the decisions of powerful states deeply impact the destiny of weak nations, especially in the era of hyperglobalization or in the area of what was globalization. Now, the skeptical view, and I want to briefly respond to it, is advanced by political theorists and philosophers at a high level of abstraction. If you read Rawls and Miller and Hegel, it's at a very high level of abstraction. As a result, it ignores historical context. Those opposing the idea of global justice entirely overlook the history of exploitation and oppressions of nations of the global south in the colonial and also the post-colonial eras. Equally, in contending the absence of a global demos, it is unheeded that the concept of demos is a relative rather than an absolute category. All communities, including those within a nation state, are to one degree or another what Benedict Anderson called imagined communities, socially constructed through the adoption of appropriate narratives and institutions. It is thus commonplace today to talk about global governance, global history, global economy, global poverty, global inequality, global cities, global cultures, global democracy, and last not the least, global justice. So this imagined community has already become global, that the demos is becoming global. The unity of humankind is also coming to be imposed by nature itself. If we are to establish peace with nature, it cannot be done without actively pursuing the value of justice in local, national, regional, and global settings. Finally, insofar as the existence of a world state is concerned, arguably, and I've argued this elsewhere in an article in the European Journal of International Law, that a nascent global state has already come into existence, constituted by a network of powerful international institutions. If we cannot see a global state emerging on the horizon, it is only because our imagination is captured by a particular form and manifestation of state, that is the nation state. The global state will not necessarily replicate in form the nation state. A third objection, I'm going through these different intellectual objections and trying to respond to them. A third objection is the absence of agreement on the meaning of justice. So even if the notion of global justice is valid, justice itself is contested terrain, or what is called an essentially contested concept. There is, for instance, on the one hand, the thought experiment approach of Rawls' term transcendental institutionalism arrived at in the original position behind a veil of ignorance. That is the imagination. And on the other hand, there is the comparative justice approach of Amartya Sen, which lays stress on pragmatic interventions in society, deploying deliberative reasons. The merits and demerits of the two approaches are the subject of much debate. In my view, the advantage of the comparative justice approach, which stresses that there are no single right answers to situations of injustice, is that we do not have to wait for an overlapping consensus on the meaning of justice before agreeing to adopt and implement policies that promote the goal of global justice. That we don't first have to agree on what justice is before we start doing anything about what the problematic situations are. We need to act here and now. The fourth kind of objection is that the translation of these broad positions on justice into operational principles. So when we are talking of pragmatic actions, intervention in the real world, what are the principles that would come to our assistance? And the argument of the skeptics is these principles are very difficult to arrive at. In my view, in this regard, the disaggregated approach of the socialist feminist thinker, Nancy Fraser, who breaks up, is very, very useful, who breaks up the concept of justice. And to students of international law, you'll find this a very useful way of thinking about justice. She breaks up the concept of justice into three principles. That is the principle of recognition, or what is cognitive justice, or the principle of representation, that is fair representation to all nations and communities, and finally the principles of redistribution, that is distributive justice. These are three different operational principles, and I will mention a little more detail with regard to this presently. The Fraser principles of justice also help us show that there is a dialectical and dynamic relationship between each of these principles, with each playing a role in realizing the other two principles, that these three principles have to go side by side, hand in hand. So you can't only talk of distributive justice. Recognition is as important as I'm coming to presently. A sentence or two each on each of these principles that Nancy Fraser advances. The principle of recognition helps underscore that many justice claims of weak nations, peoples, and groups is an acknowledgement about past exploitation and oppression, as in the case of colonization. In the post-colonial era, the principle emphasizes the idea of plurality, calling on international law to ensure equal respect for all cultures and subcultures within the confines, of course, of evolving international human rights law. In other words, reproducing the colonial civilizing mission of misrepresenting cultures, as it often happens before violence is used against them, must be avoided. As I said, it may justify violence against weak groups and peoples. So that's the principle of recognition. And you can look around and see how misrepresentation and violence go hand in hand. That's the violation of the principle of recognition. The second principle, that of representation, can assume different forms in furthering the global justice projects. There are various proposals that I don't have time to get into details. One proposal, for instance, speaks about establishing some way of direct democracy in the form of a global parliament. This is a proposal which has come from Professor Richard Falk and Andrew Strauss. A second way is to establish decentralization mechanisms to give global populations a say in the making and enforcement of international law, what the political theorists call the all-affected principle. It embodies the simple idea that democracy requires that people significantly affected by a decision should be able to take part in reaching the decision. You cannot take a decision somewhere which impacts my life without my having anything to say towards it. And the third principle is that of redistribution, which anticipates an audit of international laws to assess their impact on subaltern nations and groups. There is very little by way of social audit. How does the World Trade Organization impact global populations is an exercise which is still awaiting to be done. It calls for in the backdrop of the principle of recognition, the need to make colonial reparations and today to transfer financial and technological resources to developing nations. At a fundamental level, what the principle of redistribution requires is that the peoples of a global south are not deprived of policy space in pursuing their independent path of development. The principle of redistributive justice is not about simply resources. It is about ensuring that the weak nations have the right to take autonomous decisions which benefit their own people rather than to be tied up in complex international treaty mechanisms which bind their hands. So this was the fourth objection. As I said, I'm going through the different objections, and you'll see that while we can keep talking of global justice, at the level of mainstream scholarship, they brush this idea aside as a sentimental idea. A fifth objection to the establishing a thick relationship between international law and global justice is that the international lawyer is simply not qualified to pronounce on the distributive outcomes of an agreement and regime. How can an international lawyer actually offer analysis in this regard? Thus, for example, if growing global poverty is to be attributed to the workers of international law, it must be supported by evidence produced by economists, or so goes the critical argument. But the general lack of familiarity with the work of economists, it is argued, means that justice-driven international lawyers may misdiagnose world poverty and recommend ineffectual, insufficient, or counterproductive solutions. That is, the heart may be in the right place. Because they can't undertake serious interdisciplinary analysis, they'll come up with solutions which are counterproductive. The problem, they say, is compounded by the fact that there are different schools of economic thought, heterodox schools of economics thought, and of which the mainstream neoclassical economics supports the standpoint of global North nations. So the absence of suitable expertise means the inability to differentiate between, also among other things, internal or domestic and external causes of justice. So the mainstream will constantly argue, this is your problem. You can't get your act together. It is not as if global South nations don't have corrupt, incompetent leadership. We are more than aware of that. But that is not the entire reality. So all that can be said in response is to reiterate, while there is little doubt that incompetent domestic decisions can often accentuate poverty levels, etc., does not absolve international laws from blame. Indeed, it is often a combination of problematic domestic and international that results in injustice within nation states. To neglect the impact on global South nations of colonial and neo-colonial structures of global economy is itself a case of gross injustice. A final objection among the many objections to the very concept or idea or notion of global is that international human rights law already fills the justice gap. Why do you need something else? The international human rights law fills that justice gap. Now, to be sure, while international human rights discourse can be used to raise and pursue issues of justice, it does not readily translate into justice as it suffers from well-known weaknesses. In summary form, international human rights law is constituted of texts that have sometimes soft legal status, as in case of the Declaration of the Rights, say, of indigenous peoples or the rights of peasants, or whose the elements of human rights law, are often in tension with each other. The well-known examples of right to property versus right to health, right to property versus right to environment, and whose established supervisory procedures have often been ritualized, Human Rights Council, etc. They have become ritualized processes, ineffective. And then the international human rights law, you must remember, is often selectively invoked by powerful states to harm weak peoples and nations. And as in the case of R2P or armed humanitarian interventions, which we are seeing in the post-Cold War, beginning with the weeks of bombing of Kosovo, and whose imperialist ambitions of human rights law displaces the discourse of justice. These are well accepted criticism, many of which you'll find in the writings of Professor Samuel Moyn, the very celebrated historian of international human rights law. The result is that the exponential expansion of human rights law has not been able to stop growing poverty and inequalities in the world or climate harm. Put differently, since positive human rights law cannot help reform deep structures, that of global capitalism, global patriarchy, and global imperialism, which are responsible in the final analysis for all the global is, it cannot effectively address the justice concerns of weak nations and marginalized and oppressed groups. So IHL is great to have it, but I don't have the time, but it's very interesting that IHL, human rights law, has expanded at the same time as inequalities, both spatially and at class level, have grown in the last 4 decades. Some arguing that it has actually legitimized an unequal global order. But let me now turn to the next segment of my presentation. Now, a tentative conclusion which emerges from the discussion on the epistemic objections to firmly positioning international law to pursue global justice is that while there are complex issues involved, there are sufficiently good reasons to take the association forward. I'm not dismissing the objections entirely. I'm not suggesting there are no complexities, but I'm suggesting that these are not sufficient in order to stop us from actively binding international law to global justice. There is, in fact, an urgent need, to quote Professor Stephen Ratner, who's done much work in the area. And to quote him, he says there's an urgent need to move beyond legal analysis centered on the internal coherence of the international legal system to one that can contribute directly to a just international legal order. Even individual scholars concerned about the intricate issues involved, such as, for example, Duncan French, observes that, and I quote, notwithstanding intrinsic ambiguity, the ideals of global justice are goals worth striving towards. Though they may not always be clear, precise, or free from conceptual or political tension, this should certainly not induce us to discard them as inappropriate or unwieldy objectives for the international community to pursue. These are just two voices. But critics may legitimately ask as to what does the concept of vocabulary justice bring to international legal discourse beyond the question of justice. In general terms, so there are two sets of answers. First, in general terms, the active positioning of the global legal order vis-à-vis the goal of global justice can help indicate the structural concerns, such as the working, as I said, of global capitalism and patriarchy, which prevent the global legal order from producing just outcomes. That is, the moment you begin the global justice analysis, you will discover the foundational reasons, the very fundamental reasons why it is such an unjust global order. And the finger may point towards global capitalism or global patriarchy or whatever is your favorite sort of cause for all the inequality that exists. But more specifically, at least 5 benefits may be signposted, which pertain to method, the ethical dimensions of doing international law, the evaluation of fairness of doctrines, the highlighting of limits of international lawmaking, and promoting the legitimacy of international law. Let me take each of these benefits one by one. The first benefit is that the turn to justice can lead to the interrogation of the epistemological and ontological assumptions that inform the status quo orientation of all mainstream scholarship. It will help us question, among other things, the positivist view, and this is very critical at a methodological level for students of international law. It will help us question the positivist view that truth claims in the domain of international law cannot be solely based, as the mainstream claims, on what we call social facts or state practice. State practice, social facts are the foundation of mainstream scholarship. And what challenging the global justice will allow is the questioning of this assumption. The additional grounding of truth claims in the value of justice will allow a serious debate, as I mentioned earlier, on the causes, consequences, and just solutions to the different crises which the international community is grappling, and the ways in which global legal order can attenuate them. And that the need to move away from sole reliance on state practice, or what in jurisprudence we call social facts, is one advantage by moving towards the idea of global justice. Second, a focus on that relationship will facilitate a debate on the alleged ethical neutrality of mainstream scholarship. So my mainstream scholarship, we are not on either side. We are simply describing what international... So as Ratner observes, lawyers need to recognize that when they engage in normative and even descriptive scholarship, they often, if not inevitably, are already taking an ethical and not just a pragmatic position on issues of global justice, that there is no such thing as a neutral descriptive scholarship. You already are on one side or the other. Since I don't have time, I'll just mention the different points. A third, of course, is that the discourse of global justice will compel consideration of the genealogy and political economy of the doctrines of modern international law. I don't have the time. Most of the modern doctrines, from state responsibility to jurisdiction, their foundations are in the colonial era. And they all need to be questioned. Each one of these doctrines, even as codified by the ILC, and this will be possible if you use global justice context to interrogate them. Fourth, it will also help us understand the limits of lawmaking in the formal sources of international law. All the weak nations together, 140, 50 countries, we can't change international law. Why? Because the sources of international law are frozen in time. They can't change. Now, who ordained that it should be frozen in time is very difficult to discuss without having sufficient time. But we'll be able to challenge this notion of sources of international law, which is a very problematic doctrine. Finally, if we have established this relationship, it will promote the greater legitimacy of international law. And as was said in the morning, international rule of law is needed most immediately for our times. But that will happen only when international law is seen as legitimate. Otherwise, powerful states will use it when they want to and violate it willingly when they do not want to. These are some of the specific benefits. Unfortunately, I didn't have the time. Now, I won't get into the agents of global justice, but here are the three I already mentioned to you. There are international tribunals, there are organizations, etc. But I place a lot of emphasis in my presentation on social movements. Why? Because social movements, the movements of peoples on the ground, pursuing the goal of global justice, to them we need to do cognitive justice because they bring the lived experiences of people, whether the impact of climate change or the impact of investment regime, they bring it to the world of international law, and they need to be actively supported, these social movements, if we are to achieve global justice. I'll just take a minute more in my final remarks. I don't know. So I have argued that we need to pursue the goal of global justice. Because, why? One may ask as to how many generations have to pass before international law stops facilitating the exploitation and oppression of subaltern groups, peoples, and nations. How long are we to wait for a global legal order which ensures that weak peoples and nations cease to be the subjects of immeasurable and endless violence? Immeasurable and endless violence. And how long, finally, that we can tolerate the subordination and commodification and commercialization of nature, even at the cost of ending life on planet Earth. The road ahead is not easy. I try and talk about the road is not easy because we know populist regimes who dislike international cooperation, dislike multilateral institutions, dislike any attempt at curbing unilateralism are today in power. But we have no choice but to push ahead. And my final request to all students here is that this is the time for any one of us interested in international law to be stand up and be counted. This is the time when we stand up for people and groups who are witnessing, as I said, endless violence. And if we can't use our scholarship to do that, then we are doing disservice, in my view, to international law, to the language and vocabulary of international law itself. And that would be a pity. Thank you. My apologies for exceeding my time. But how does one speak of all the tragedy around the world in 45 minutes? I don't know. I tried. Thank you.